these are all analogous matter. By order dated 3/6/2025, this Honorable Court has stated that both interlocutory application and review petition will be heard on merit. So on the last occasion, item 8, 9, 10, and 11. So I need to serve a copy to the private.
8,
9, 10,
9,
and 11.
10 and 11. This is for order only.
All are analogous matter, my lord.
For what it has been listed?
It has been listed for orders, but
Orders, but what?
my lord, but as per order dated 3/6/2025, this Honorable Court has held that the both interlocutory application and the review petition will be heard on merit. So to come prepared with the review petition. Though I need to serve the copy of the review petition to the private respondent in all the cases.
Yes.
So today, during the course of the day, I will serve the copy, and I have taken consent from as a government advocate as well as
not
the
yet
private.
serve the copy.
Today only I will serve review petition.
Yes.
Because only IA was served. So since this Honorable Court will hear the review petition as well.
Whether the respondent would appear?
All the respondent has appeared, my lord.
Okay.
Private respondent as well as the government advocate, my lord. I have taken consent.
You are going to serve copy today only. You are going to serve copy today only.
Today only.
Okay, Mr. B.K. Singh.
Yes, my lord.
Learned counsel for the applicant. Some mistake. He has not yet served copy to the respondent. However,
Respondent
he is
number
ready
1.
to serve copy of the review petition to the respondents today itself.
Today.
Okay. And then?
My lord, the matter may kindly be fixed on 12th of September.
Okay.
For.
And praise for Father praise for listing this matter on 12 of September.
My lord.
Okay. He has also obtained consent from the Land Council for the respondents. And view of the above, let this matter be listed on 12 September.
Okay.
So this is 8, 9, 10, and 11. Okay.
Your Lordship, I beg to mention item of 5. I am appearing on behalf of Deep Panging.
Item
5. I am appearing on behalf of Deep Panging, respondent. Conducting counsel out of station.
You are for the respondent?
Yes, Your Lord.
What do you want? Your prayer?
So, conducting counsel out of station.
Council is out of station.
Yes, sir.
Have you informed the Land Council for the?
Yes, Your Lord. I have informed.
You are okay. Mr.
Tajo.
Your name is there?
No, Your Lord.
C?
Appearing on behalf of Deep Panging, Your Lord.
Okay, C.
Tajo.
Land Council. Some is that the Land Conducting Council for the respondent. Respondent number?
Sole respondent.
Respondent is out of station. Therefore, pray for adjournment. He has also obtained consent from the Land Council for the petitioner. In view of the above, and as prayed for, come and list this matter, adjourn this matter for 2 weeks.
2 weeks.
Okay.
Oblate.
Then list this matter after 2 weeks. Huh? Okay.
Mayor Lordship, I want to be the concern of other party. I beg to mention item number 12 on behalf of B. Sarman. The conducting council is out of station. Therefore, my lord.
So this is for order. Let us see why it is this been listed for. Okay. We'll grant you adjournment, but wait for some time. Okay. Let us see the record.
Obligation.
I would like to mention item number 7 for adjournment. Your Honor, matter will be taken up of this 12 of this. The main council is out of session.
You are Mr.
C. Peter.
Your name is not there.
No, Your Honor.
Mr. C.
Peter.
Some Mr. The conducting council is the council for the petitioner is out of station. Therefore, praise for listing this matter.
12.
Why 12?
Because he instructed me to take this.
Praise for listing this matter on 12 of
This month.
August.
Yes.
Okay. The prayer is allowed. List this matter on 12 August. Okay.
Much obliged.
My lord. Basically, my lord, I'm challenging this order. Challenging the order dated 22 July 2025, passed by learned Civil Judge Senior Division 0, my lord. Passing interim injunction against the Deputy Commissioner in respect of 2 plot of land, my lord. My lord, to come to that point, before coming to the point, my lord, I'll highlight the brief fact that lead to the passing of this impugned order, my lord. Although that order is without jurisdiction, is illegal, my lord. I'll come to that point. First of all, my lord, the petitioner herein, my lord, along with other, had filed the title suit way back in the year 2016 by the title suit number 14 of 2016 before the Learners Senior Civil Judge Senior Division 0, my lord, for declaration of 3 plot of land, my lord. First is Langria, Changte Yarwe, and Taik Langpak, my lord. My lord, the title should, my lord, you see at page 18 onward, my lord. This is title should filed by me, 18, my lord. And this present petitioner, my lord, is plaintiff number 2, my lord. Bingya Kasuk, along with other, my lord. And at 19, my lord, you see defendant number 2 is the respondent here in, my lord, in this civil.
Page 19.
Yes, page 18 is plaintiff, my lord. Plaintiff number 2 is the petitioner here. And the 19, my lord, plaintiff number 1, defendant number 1, Chelo Mopam, is the respondent here in this civil division petition, my lord. Now, the main scheduled plot of land, my lord, will see at 3 plot of land start from page 24, my lord. First one is, my lord, Langria, location Buyang Blaze, area so my lord. 2 is Changte Yarwe, location Buyang Blaze, area so my lord. Then third 25, my lord, Taik Langpak, my lord, location Buyang Blaze, area 13,000 so my lord. This 3 plot of land of the this was subject matter of the title suit before the learned Civil Judge Senior Division, my lord. The UPI, my lord, will challenge title over this land, my lord, against the defendant, my lord. Now, during the pendency, my lord, the government of Arunachal Pradesh has issued a notification, preliminary notification, expressing their intention to acquire the land for the purpose of construction of frontier highway from Sarli to Huri, my lord. And that notification, preliminary notification, was published under Section 11 of LARA Act, Land Acquisition Act 2013 on 1st February 2024, my lord. Now, under 11, as per, my lord, Section 15 of LARA Act 2013, my lord, the claimant objection, any person who's affected and who's interested, they have to make a claimant objection within the period of 30 days, 60 days from date of publication, preliminary publication, notice publication under Section 11. Now, Section 15, 60 days time has been lapses, my lord, after publication by the first week of April 2024. Now, thereafter expiry of this period, my lord, claimant objection, my lord, within this period, there was no any claimant objection on part of the respondent herein, my lord, because that land does not fall under any of the suit land, my lord. Now, after expiry of this period, my lord, the Deputy Commissioner Kurung Kume District, my lord, under Section 21 of the LARA Act at page 61, my lord, the public issued a public notice, my lord, final public notice, my lord, after complying, my lord. 61, my lord. This is a public notice, my lord. This public notice, my lord, finally, not after notification detail, my lord. This notification detail, this preliminary notification was published on 1st April 2024. My lord, intending to acquire these, my lord, the area falling under these stretch, my lord, Sarli to Puri, my lord. Then, my lord, what happened after detailed ground survey and assessment, two private plot of land of the present petitioner, which was not the subject matter of the title suit, my lord, they was found to be affected by the by the project of Frontier Highway, my lord. The first plot is appears at serial number 179 of the list, my lord, 179 at Bulak, yeah. And second plot of lands of the petition appears 133, my lord, located at Sangrik Yiriang, my lord. And these two land, my lord, that the serial number 179 and 183 appears in beneficiary list in the award, my lord. That was not a subject matter of the title suit before the trial court, my lord. Then all of a sudden, after completion of all this, after the name of petitioner and beneficiary that was published in the award, showing the name list, my lord, against particular plot on the stretch. Then all of a sudden, on 23 June 2025, my lord, this respondent has filed a complaint before the DC, my lord, Deputy Commissioner Kurungkume. My lord, you see at page 59 to 60, my lord. 59 is the complaint. This 23 June 2025. This complaint was lodged before the Deputy Commissioner, saying that the plot of land which appears as serial number 179 and 183 belongs to him and not to the petitioner. That does not belong to the petitioner. This complaint was lodged, my lord. And in this complaint, there's no even whispering. There's no any whisper about that any of this land falls under suit land, my lord. There's no expression, there's no whisper about it, my lord. Now, as I have already stated, my lord, for acquisition, my lord, there's a series of sequence events there. Preliminary objection, it was published on 1st February 2024. Inviting claim and objection. Then in terms of section 15, it has to be any person who's interested and the objection has to be filed objection within 60 days. In terms of section 15, that has been done, my lord. No claim objection has been submitted by the present respondent. And all of a sudden, this complaint was filed after completing entire, my lord, after passing the award and publishing the award in the public notice, my lord. This complaint was filed, and in this file, except saying that this serial number which appears that belongs to me, nowhere as whispered, there's nowhere mentioned that this lens is the subject matter of the title suit, my lord. Now, in this regard, my lord, the Gangra of Buyang Blaze, where these two stretch of land falls, my lord, they have clarified, they have in writing clarified that lands belongs to the petitioner at page 63, my lord, see, 63. This is in respect of serial number 179, my lord. This Gangra Buyang Blaze. Clarify this land belongs to me, my lord, to the petitioner. And page 64.
You are aggrieved by which order?
My lord, page 64. Now I'm aggrieved by, my lord. In this regard, again, I file also representation against restaurant. So, my lord, their claim of the respondent. My lord, I'm aggrieved by the impugn order at page 15, my lord. During this, my lord, after approaching the DC, Deputy Commissioner Kurungkume, and I've also filed the objection on my part. They filed the injunction being IA number 32 of 2025 before the Learned Civil Judge Senior Division 0, as page 15, my lord, see. And here, my lord, Deputy Commissioner was not a party in the title suit, my lord. Page 16, page 15, as operative portion is 716, my lord. Order dated 22 July 2025, my lord. Third paragraph, heard learned counsel, 16, my lord, page heard learned counsel, peruse the application Without implementing the DC Kurungkume district, no injunction can be issued. However, taking into consideration the recent development, which is the publication of the land compensation beneficiary list in the month of June 2025, an area of the applicant defendant in the main case, that name of the plaintiff too is shown in the beneficiary list for compensation with respect to some of the areas which are the dispute before this court matter. This is the first time it is raising because it was never raised before the even deputy commission. In the interest of justice also,
So otherwise, according to you, these are not the disputed,
my lord.
not the disputed land.
Yes, in my representation, I have claimed, and they have also said that it's not
No, no,
disputed.
according to you, this, the land in question is not in disputed in the title suit pending before the court.
Yes, it was not subject matter.
It was not a subject.
Yes,
matter.
yes. The serial number which there's shown as malab in the serial number malab that particular location of the street, that was never the subject matter. It's not the subject matter of the dispute in the titleship matter.
Okay.
Now, in the interest of justice and also to protect and preserve the subject matter, which is the suit land by name of Langria, so and so malab 3 location of the area. This court is inclined to direct the DC Kurungkume district not to disburse the compensation to Bingya Kusuk, the plaintiff too, in the main case whose name is reflected in serial number 179 and 183 of the list of beneficiary list till conclusion of trial. According to the DC has been directed, my lord. Now, in this case, my lord, my respectful submission, my lord, this injunction order passed by the London trial court, madam, it is absolutely, madam, without jurisdiction and is violation of the section 63 of the Land Acquisition Act 2013, madam, because it's relates to the acquisition part, madam. Whenever there's an acquisition compensation part is concerned, madam, there's a statutory bar against this civil court, madam. Page 63, my lord. And next is also extract part. My lord, see at page 17A, section 3 of Lara Act 2013.
78.
17A, my lord. 17A. Page 17A. This is extract of the Bear Act only, my lord. Section 63, my lord. Jurisdiction of civil court, bar. No civil court other than High Court under Article 226 or Article 227 of the Constitution or Supreme Court shall have jurisdiction to entertain any dispute relating to land acquisition in respect of which the collector or the authority is empowered by or under this act, and no injunction shall be granted by any court in respect of any. Now this, the impugned order dated 22 July 2025 has been passed in violation of this order without having any jurisdiction, matter. That is none is in the eye of law, because under this statute, Land Acquisition Act, matter, even if there's any disputes with regard to title or who would be receiving in that would be a rightful person to receive the compensation and all, matter, there's a specific provision as to how this matter can be dealt with by the authority. The authority to deal with such dispute is the only deputy commissioner, matter. Or if the deputy commissioner cannot resolve it, it can be referred to the authority, my lord. That is reference authority is there, my lord.
Okay.
Tribunal is there. Now,
Petition notice.
my lord, in this regard, my lord, I have a interim prayer, my lord.
Pardon, Mr. Ikabu. Land counsel for the petition, land counsel for the petitioner. The petitioner file this petition under Article 227 of the Constitution of India, read it Section 115 of the Civil Procedural Code 1908, challenging the order dated 22/7/2025, passed by the Court of Civil Judge Senior Division 0 in IA number 32/2025 in title suit number 14/16, whereby whereby it is directed the Deputy Commissioner Kurunkume District not to disburse the compensation to not disburse the compensation of the petitioner to you,
My lord, yes.
to the
Hingga
petitioner,
petitioner.
petitioner, within bracket plaintiff in the title suit,
Yes.
bracket close. Whose name are reflected in serial number 179 and 183 of the list of beneficiary till the conclusion of the trial. It is submitted that the aforementioned land reflected in serial number 173, 79 and 83. This belongs to you,
Yes, madam.
of the petitioner,
Even Gambura also certified that.
are not the subject matter in the title suit. Number
Number 14 of 2016.
14 of 2016.
Number 6.
Start off. It is further submitted that under section 63 of the
Right to fair compensation
right to fair compensation
and transparency
and transparency
in land acquisition,
in land acquisition,
rehabilitation,
right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013.
Yes, ma'am.
Bar, clearly bar. The civil code from passing any injunction in respect of the subject matter of the
Land proposed to be
LARR
acquired.
Act 2013, except the High Court of the concerned jurisdiction. The section 63 of LARR Act 2013 is reproduced herein below. Type it, okay? From section 63, huh? In view of the above provisions of law, the Land Council for the petition of some statute, by passing the impugn order dated 22/7/2025, the learned civil judge senior division has exceeded the jurisdiction not vested on the state court.
Well,
Stop. Issue notice. We need to call for the record.
Madam, we can call for one.
Okay, call for the trial court, scan copy of the trial court record. Issue notice. Making it returnable by 4 weeks. The petitioner shall take steps upon the respondent by arranging support with AD as well as by usual process within a week from today. List this matter after 4 weeks. In the meantime, there shall be stay on. Where is your intent?
Madam, at page 13, madam, I have read my entry, madam. To stay the impugn order dated, madam. Under section 77, madam, the deputy commissioner has a power to settle in case of any dispute, and it cannot be settled. Amount can be deposited to the authority, madam.
The operation of the impugn order dated 22/7/2025 shall remain stay. Till the next returnable date. Do we need to direct the deputy commissioner to disperse as per the?
Yes, as per the
No.
act, madam, deputy commissioner is the authority, madam. Even if there's this on his own assessment, if there's really
However, it is made clear that the deputy commissioner shall disperse. And where is that? The deputy, where is the that way the deputy commissioner is to disperse?
my
Where it
lord,
is?
my lord, provision 77, my lord. My lord, in the
No, where have you stated that the deputy commissioner is to disperse?
my lord, that case, my lord, the section 77, my lord, it's make clear, my lord. 77 Lara.
The same act.
Right. Yes, same act, my lord.
This is land acquisition. This act. Provide one copy of this. Not there. The deputy commissioner shall proceed with the disbursement in accordance with the law.
My lord.
Okay.
Under that provision, my lord, if there's any, after assessment, if they still find that there's dispute, he can deposit the amount to the authority, my lord, the reference authority, constituted under the act, my lord.
563 from here. Okay.
Deeply observed.
So this, let me find out if this last sentence, if not required, I'll delete it.
Right.
Okay, let me find out after reading the provision. Let me
My-
read the
My
provision.
lord, my lord.
Okay.
Let authority do in their accordance with level.
Then accordance.
My lord, that.
Okay.
Deeply observed.
May I please, your lordship?
Yes,
My lord, by this CRP, the petitioner has challenged the impugn execution order, my lord, passed by the circle officer, Payam Circle, my lord, which is at page 20, my lord. On 6th, my lord, by a summon, I was issued a summon on 6th of June to appear before the circle officer on 10th.
page, you said page.
The summon is at page 25, my lord.
25.
Yes, my lord. So,
Yes, what is this?
the summon is at page 26, my lord, sorry,
26.
26, yes, ma'am.
What is 25?
So, 25 is the translated copy of Kawang decision, ma'am.
Okay, so first we need to see this notice.
Yes, my lord.
Notice was issued by?
By the circle officer, in the capacity of executing court, my lord. May I read, my lord?
Yes, please.
Whereas Sri Takangadu, who is the respondent, a decree holder has filed an execution case against you, judgment letter in connection to the Kabang decision passed on 14/2/2025. Hearing speaks on 10/6/2025 at 10:30 hours at the court of the circle officer Payam. Therefore, you are directed to appear personally or with an advocate along with relevant records. So, in
This was
compliance,
issued on 6th June.
yes,
So who is this Tucker?
this is circle officer, madam.
No. This Tucker is the decree holder.
This is the respondent in the CRP, my lord. The
Respondent.
so-called, yes. ma'am.
Okay, okay, this Tucker.
Oh,
Gadu, decree holder.
Takangadu is the, sorry, my lord, petitioner, madam.
Petitioner in?
A petitioner in the CRP, my lord, in present CRP. So accordingly, my lord, in compliance with this summon, madam.
You are the Tucker, Tanya Tucket.
Yes. Yes, the petitioner is Taket, my lord.
Tucket.
Yes.
The notice was issued to whom?
To both the parties, madam. Down below, both the
Okay,
parties.
just a minute. Huh?
To Tanyat Paket oblique Pangu. So this is the petitioner, my lord. But the copy has been also served to the respondent, my lord, down below. Copy to Sri Takangadu, who is the respondent, my lord, for information and necessary action.
Okay, and then where is the Keba decision?
Yeah. The Kebang decision, my lord, is at page 25.
You are? Right, okay.
Banyak.
Kanye Paket.
Yes. Lord.
So the Keba pass order against you.
Yes, my lord.
And then,
And
then you did not file any appeal.
yes, my lord. Because
So they file execution petition.
yes, ma'am.
So this was the notice in the execution petition.
Yes.
What the executing court, you are agreed by the impugn order 10-6.
Yes, ma'am.
Okay, what is this 10-6?
They
What it says?
in the 10-6 order, my lord, the executing court has held that I did not file any appeal
Okay,
in time.
that is why they proceeded.
Yes, ma'am. That is the only ground, my lord. But your lordship, we have not been even furnished the copy of a certified copy.
Yeah,
of
you have only been directed to comply with the order only.
yes, my lord.
No, any other passed in the execution
Yes.
petition, any other adverse order, whether any adverse order has been passed in the execution petition, other than directing you to comply with the order,
No, my lord. But the
then how you are agreed by?
impugn Kebang is against me.
Okay, you are challenging the Keba decision.
Yes, my lord. But I have not been even furnished with a certified copy of the Kebang decision because the present respondent.
Where is the application that you have made for furnishing of the copy, applying certified copy, where?
That today I have not anything.
That means you have not applied.
No.
Then
No.
unless you ask and unless you go, who will bring it for you? You have to go and ask for the copy. You have to create your case. That I have applied. That's part of my application for furnishing of CTC. They did not give. Unless you saw it, you did not apply. You were sleeping.
Lordship, they are not even ready to receive my application because this
Who
respondent.
says? Who says? Where
Is a-
do we find that they are not ready?
This respondent is an influential person in the area, man.
So what? But then you have to see somewhere because
but-
they are Gamburas.
Yes.
Anyone in the village, not only one. If the person, one person is not accepting their other Gambura, please pass it, give it. In the office also, if the officer is not ready, then there is a branch, there is other officer, other staff, get it received. See, then unless you saw that, it is assumed that you did not apply.
The normally, Lordship, the decision of Kewang remain with village secretary, my lord. But in the instant case, there is no such village authority even because the Kewang itself has jurisdictional error, my lord. Even this court has observed that Kewang was conducted by the inter-village territorial councils, which is an appellate court.
No, that is why. Have you challenged that?
Yeah.
Where?
Now,
What is your prayer? Let us see your prayer.
in the averments, Lordship, we have mentioned the jurisdictional error of the impugn Kebang decision. And now, with or without the certified copy of the Kebang decision, we're ready to prepare an appeal, my lord. This execution order itself.
Unless you challenge the Keba decision, how do we interfere with the execution petition? There is no stay in the against the Keba decision. Then execution proceeding, this has to proceed.
Lordship,
What can we do?
Lordship,
You have to, first of all, you have to challenge the very decision, the Keba decision. Unless you challenge the Keba decision, how do we interfere with the execution?
Lordship, the
Execution
CTC
has to go.
a certified copy of the Kebang decision is not being furnished to us. So without that, we are not able to file even. But now
No, you could not show anything that you have taken any steps to obtain the certified copy of the order, only giving statement in the petition. Who will believe? Nobody will believe. Everybody knows that this is only statement by the advocate, not even by the client. You have to show something that you have taken steps to obtain.
The
That's
application, the application that is not being received by the village authority, that we are going to punish, but because this
Even
guessing,
if you have written any application, given it to the Gambura, even if it is not accepted also, but then you have to write a date and write that it was not accepted. He is not ready to accept. Then we'll make him party, implead him. See, unless you do those things, shows the court, satisfy the court that you have taken some step at least by sitting in the chair, preparing petition. We are not going to believe.
Lordship, this guessing,
Now, how do we make party? You have to prepare, make a proper allegation against the party. The person who refused to accept the application or refused to furnish.
Lordship, my prayer in the executing court for engaging a counsel was not even allowed, my lord, because execution court, execution
See,
order
the
was passed.
executive, why you have challenged the execution petition or executing proceeding, unless you challenge the main order. Unless that is order, executing court cannot do anything, can't change anything, can't alter, not even comma. He can't change. Even if you pray also, even the executing court knows that the land belongs to you or the property belongs to you also, but he can't do anything unless you challenge the very order of the kebab.
But Lordship, at least I ought to have been allowed to engage a counsel of my choice, actually.
Where?
In the executing court, man.
You engage, who prevents you from engaging? Who prevents you?
My prayer was not even heard, my lord. So we didn't feel this.
See, if the prayer was not heard verbally, then you see, you create by filing application, petition, complaint, whatever manner is possible on your part. That what next? As a normal human being, what next? What next? Automatically, no, it's not a complicated thing. It doesn't require so much of brain. Even the foolish person also will find some alternative. If he is not, I accept, I'll approach this. Why you did not do that? See, you just tell me, can we interfere with the execution proceeding unless you challenge the Keba decision, the very decision? Can't. Under what provision? Execution court only here in this case only says that you comply. He is reiterating the order of the Keba. But you have failed to challenge the order of Keba order. Challenge the Keba order first.
Lordship, because I am a layman, but the opposite party was represented by his counsel. So,
but now your client is represented by you, advocate. You can suggest now. It's under your hand now.
So this court even has interpreted in a similar case.
I have no idea. Where is that?
But the execution order passed
Not
by
possible.
the same.
Not possible. Nalopada, not possible. Unless you challenge the order, impugn order. Unless you challenge the order itself. Interfering with the execution proceeding is not possible. Kindly show me if there is any order.
We have challenged the execution order also.
So that is what I'm saying. Unless you challenge the very order, execution petition, he is bound to proceed with as per the provision of the law. Now you are not ready to challenge the order itself.
or
in the order, if you challenge the order, then if the order is challenged, if the court finds something, then only the execution proceeding can be stayed. If the court satisfied that you have some case. But only the execution petition, unless you challenge the order itself.
Lordship, we have pleaded in the executing court that we can, I cannot be left remediless, so I'm ready to appeal against the order.
Why all those? Why all those? Basic thing is only one question, only one answer. Only one action is to be done. Challenge the very order. Thereafter only those thing comes. Why that it didn't strike even your mind? See, you have to challenge the order first.
Of the Kabang decision.
Keba decision only. Thereafter, in the Keba decision, against the Keba decision, you will be stating your right and entitlement. And then the court will examine if you have a case, if the court finds that you have a case, then execution petition. Because you will be again filing against the executing court also, proceeding also. The appeal is pending against the Keba decision. But in the meantime, this need to stay. Unless the execution proceeding is stayed, the appeal will become infructuous. Automatically, the court will pass some order at least protecting the right, protecting the property from damages. Okay, I think you have to challenge if you want to keep this pending, and in the meantime you want to file. We'll keep it pending for some time. Or you want just notice to be issued. No stay. Because now he will come and say, he did not challenge. There are no challenge against the order. How the execution petition can be stopped? Apply logic and law.
Lordship, but simultaneously with.
Yes, even if now also, if you can file, it is before I think the trial civil judge appeal lies before the civil judge.
Yes.
You file first. And then how do I tell you the entire proceeding? You have to take this, take that. Huh? So you challenge that, but here if you want notice to be issued, notice can be issued, but automatically you'll be in a difficult, in the awkward position, because unless you challenge that one, you will have no answer. Withdraw it, challenge that first, and then come. The appeal is pending, this need to be stayed.
Yes.
Or what? If you are still confused, we can keep it pending. I can issue notice also.
Lordship, I may be allowed to withdraw with a liberty.
That will be better. You file immediately, you file appeal against the Keba decision, then make a pray for a stay of the execution proceeding. Okay. Mr. N. Pada, Land Council for the petition, wants to withdraw this petition with liberty to file a press if so advised. Okay. So I'm giving liberty. Okay.
May I have lordship?
Yes.
May I please your lordship? Lordship, this is an application under section 528 of BNSS Act 2023 for quashing of an FIR, your lordship, to prevent abuse of legal
State
process.
is also party.
Your lordship?
State is also party. Yes, lordship.
Yes.
Okay. Yes.
Yes. Your lordship, this case arising out of Deun Bajar under the Sanglang district, your lordship, of Arunachal Pradesh in connection with PSKS number 1525, book under section 329 of clause 3, BNS Act. Deals
Under section?
329, your lordship.
You are, where is the impugn order?
Your lordship, this is not order. This is just a registered FIR, just quashing of an FIR.
Where is the FIR?
Your Lordship,
Not an
You
ex
must-
lordship, not an ex lordship, FIR not an ex lordship. He is
Your Lordship,
restrained for.
certified copy is not given to me, Your Lordship. I have already.
Okay,
seek-
you are
yes,
challenging the
yes,
FIR, which is not with you.
yes, Your Lordship.
So-
Actually, a prior copy is not given to me, certified
So
copy.
we'll have to, your prayer is that there is some FIR, there is some document called FIR, which is not with you, and there is some, must be some allegation to quash that. That is your prayer.
Yes, Your Lordship, actually,
Can
Uh,
it be? Can it be?
Your Lordship,
Can it be? Unless we see the copy of the FIR and the allegation against you, which is to be set aside, then how do this court,
Your Lordship,
they go about?
I have seek 2 or 3 times to IO to seek, punish the copy of FIR.
Where is
certified
the,
copy.
where is the application you made before the IO of the case? Let us see.
Application, Your Lordship.
Application applying for the CTC of the FIR.
No, actually, sir, Your Lordship, I have not applied CTC copy because it's gone for the late. This is why.
Because it is
Yes,
gone for.
late. Maybe delay, Your Lordship. Your Lordship. If I
Delay.
supposed to apply the CTC copy of to obtain the copy of FIR,
Hmm.
it may be delay.
Delay what?
Your Lordship, this is very special kind of case. If this
I-
honorable court may be
How
along
it
with
has
it,
become
then
special?
read detail, Your Lordship.
It
I
is
have
not
furnished
acquired
all
as
the documents I have furnished along with this petition, Your Lordship.
No, no.
Your Lordship,
Direct counsel,
yes,
you are praying for the quashing or setting aside
yes, Your Lordship,
of certain things.
yes.
We need to see what is that things which are going to damage it, which you are going to quash it, set aside. We need to see that. Where is that?
Yes,
Unless you show that, it will be difficult. And if you,
Your
see, the
Your Lordship, my prayer is to call for the record to for the respondent, Your Lordship. Respondent number 2 is FIR lodged by the respondent 2, Your Lordship.
where have you stated that you have not been furnished?
Actually, Your Lordship, I am aged person. I am at the age of 89, with almost
Wait,
80 years,
wait,
Your
wait,
Lordship.
Wait, age is not.
This,
But then let us see, where have you stated that you have applied for the, or you have asked for the for furnishing a copy of the FIR and that was refused? Where have you stated?
Your Lordship, I haven't attached this, said, the CTC, I have not been applied, Your Lordship.
See, some basic steps are to be taken by the client, and if the client fail to do, when it comes to you as an advocate, it's a duty of the advocate to suggest them, to advise them, and to lead them step by step. So, see, and then only on the basis of the verbal instruction, it's very difficult unless you do something to make out your case. In the earlier case, see, he was to do something which he did not. And here also it's same only. So unless the FIR is there, which are seeking for quashing or setting aside,
Yes, Your Lordship.
so how do we? And even for issuance of notice.
Your Lordship, in this case, I am a poor person. I am a poor people of this Dayon area, said area. The police is not listen to me, Your Lordship. Police is not listen to my request, Your Lordship.
And no, that is why even the police doesn't listen also. When it comes to you, you could have actually prepare one application for furnishing of the copy of the FIR. He is entitled, the accused is entitled as of right, a
Yes.
copy of the FIR. You are entitled. You apply for that. If they fail, then come before this court. Although I have applied, they did not. And you have not even, you are not even ready to give a statement also, or state before the court also that I have applied, not furnished. Then how do you expect this court to interfere or to pass any order, effective order under the circumstances? Please don't expect that much from the court. Do something at least. You first apply for the copy of the FIR, obtain it, and if the police say that apply to the OC, I'm entitled for the copy of the FIR against me. Furnish the copy, get it received, acknowledge, and then if they fail to furnish, then with that you come. We'll call for the record. But then if you have not done that also, sitting at
Your
the
Lordship,
Tanagar,
I have copy of FIR, but that is not true copy. That is not certified as a true copy. I have,
maybe, wonderful, you have a copy, annex that, and then say that the copy which I've applied is not a certified copy, but although I have a copy, this is not a certified copy. Give that statement. Mr. Land Council, annex that FIR copy which you are challenging, the impugn order. It will be difficult unless you, and there will be a defect in your petition. That basic statement is required, necessary for proceeding with the case. Isn't it? Have you got it?
yes, Your Lordship.
Do you have the copy?
Yes, but it's not true copy, Your Lordship.
Maybe,
That is why I could
maybe.
not able to punish along with
Maybe
this
that's
petition.
not a CTC.
Yes,
Maybe it don't have to be a CTC if you have not been furnished. You just give a statement that I applied for CTC. CTC did not provide this. This is the copy. Advocate will certify. Or what? You want to withdraw? I think there, because if you have not stated that also, it will be difficult. Better you withdraw and file it. Annex that if you have a copy, and you have there will be no delay in filing. The condonation doesn't apply. I think this for filing criminal petition. Doesn't it? Right?
Condonation not required, Lordship.
It's not required.
Oh.
You are Mr.
Teleango, T-Ango.
Teleango, Land Council for a petition. I want to withdraw this criminal petition with liberty to file afresh after making necessary correction. Okay. This. Okay. The petition dismissed on being withdrawn with liberty as per effect. In both, in earlier also.
May I please, Your Lordship?
Yes.
Hello, this matter is we're challenging the order passed by the Learn District and Session Judge.
Order passed by?
District and Session Judge Khunsa.
Okay.
In this case, there is an order.
Just a minute. This is criminal petition.
Yes, we are filing for set-aside and quashing of the impugn order dated 12/6/2025. So in this matter, what happened is that the concerned Chief Judicial Magistrate have passed the maintenance order, and that maintenance order was challenged before the District and Session Judge. They have the District and Session have
Appeal. It
yes.
was the final order.
criminal revision petition before the District and Session Judge.
No. The order passed by
Order passed by
magistrate was the final order.
yes, order passed by may I just take to that order is in page 18. Start on page 18, and
Yes, it is final order.
and this operative in page 31. The direction was that the maintenance has to be paid to his daughter, but then the amount was exorbitant. So accordingly, the petitioner has challenged before the District and Session Judge in the form of criminal revision petition. Your Lordship may see in page 34. Page 34 is the criminal revision petition. Page 34 is the criminal revision petition.
This is the
Page 30, sorry, not page 34. We just take to.
This is a criminal revision.
Yes, that was filed before the District and Session Judge.
You have filed revision against the final order, not appeal.
Not appeal. It was a criminal revision petition. In fact, the
Revision
concern.
on what ground?
I think I must just take to that.
Final order should have been appealed. Okay, anyway, what order was passed in criminal revision?
criminal revisions, the matter was registered as a criminal revision petition. I will just take to page 34. After filing the criminal revision petition, the matter was heard on 9/12/2024.
Okay.
It's in page 34.
Hmm.
May I just read that one?
Hmm.
And then in this order dated 9/12/2024, the maintenance order which passed with the
Okay, interim.
interim was passed.
So
So in-
initially it was 50,000,
Yes,
but then now interim 30,000.
30,000. Yes,
Okay,
30,000.
Finally, your case was dismissed.
Yes, and then what happened was that matter was again. I will just take to the another order. Is in page 37. Page 37. 015/2025. As per this order, the next date is 12/6/2025. May I just see the last paragraph?
Yes,
Yes, it was fixed on 12/6/2025 for
Yes.
final argument.
yes.
So now what happened on 12?
For final argument,
Yes.
yes.
No. What happened was in 12/6/2025, the counsel for the revisionist,
Remain absent.
he remained absent. That is us. He was unavailable because of the unavoidable circumstances. He was not present on that particular day. So the impugn order is on page 54. Just married.
Yes.
Page 54 is the dated order dated 12/6/2024.
Okay, so your
So now,
application was dismissed.
yes, application was dismissed saying that
Technical ground.
on a technical ground, saying
Then-
that
Not on merit, not on merit.
not on merit.
Yes, then,
Application was yes. So that's what we are challenging this impugn order.
application, make application, same application before the same court under BNSS.
So,
Why
but
you
then-
have challenged, why you have challenged?
But if this order is available, then the concerned court may say that your application has been already dismissed. So how?
It was on a technical ground only.
Yes,
That's not
yes.
filed under CRPC.
CRPC,
It's
yes.
after the enactment of this, then after 1/7/2024, it has to be under BNSS.
Yes.
You file under BNSS.
So, but then
Make same prayer.
Right.
How do we, what do you expect this court?
But then, your lordship, basically, instead of dismissing this matter should have been the revisionist should have been instructed.
You should have been allowed.
He should be allowed to file
amend.
under BNSS, or this petition could have been converted into
But we
BNSS.
deliberately filed under CRPC, when you already knew that the BNSS, it has to be under BNSS. after
Yes.
1/7.
Yes. But then this, I think, concerned lawyer who was appearing this matter, he filed under this one.
Okay,
criminal
we issue
petition.
notice.
Yes. And this order matter
Yes.
is suspended.
We issue
till-
notice.
Yes, Lordship.
Hmm.
The correspondent number 2 is there, Lordship.
Oh, yeah, your lordship may dispose of, with observing that fresh application can be filed before the concerned district assessor, then that will also suffice the matters.
No, because there is a private respondent.
Yes, private respondent.
And that order would be against the private respondent.
Exactly.
That in
And
that case, we cannot.
yeah, even order also, it says that the earlier order passing the maintenance should be executed. That is as per the impugn order. So I think it has to be challenged here also. That's what we are praying for, this setting aside and quashing of this impugn.
No, see, advocate taking so lightly.
The
And
order,
Court at time, of course, most of the time are very, of course, lenient, most of the court. But then cannot expect the same attitude, the same.
but then your lordship,
situation.
in fact,
So
his
on that day, or before that also, if you have, you were indicated that it has to be under BNSS, would have made a prayer, small prayer, allow you to amend the
basically,
section, or by filing, or by amending the section only, for amendment. of the
yes,
section only.
that should have been done. Your lordship.
It's the question of amendment of the section only. And then you yourself.
At least when the final hearing concerned lawyer is not present, at least one chance should have
No,
also
no,
given
no
that.
chance.
Right.
There are other persons. You have
Yes,
not
yes.
paid.
Yes, that's what.
You are so rich, but you have not paid to your son or wife and
No,
children.
they are ready to pay your same. Only the question was that only amount differences.
Amount 50,000 is very less for you.
I don't know.
That's it. You have so many profit.
So, well, may issue a notice and this may be stay till the returnable date so that can be disposed in next hearing, Your Lordship.
Card Mr. S. Mo, Learning Counsel for the petitioner. This is an application. File under section 528 BNSS, related Article 227 of the Constitution of India. Challenging the order dated 6/2025 passed by the district and sessions. It must be sessions judge only.
Sorry?
Okay, district and sessions judge. Consa Sessions Division. In KSA, in case number KSA, stroke, revision, within bracket, CRL, criminal, bracket close, number 03/2024, arising out of, what was the main case?
Yes, main case is in maintenance number 01/2022.
Arising out of the maintenance case. What is number, give the number?
May see in the page 18.
Maintenance case number 01/2022. Yeah. It is submitted that the criminal revision KSA, what concept? Stroke revision within bracket criminal number 03/2024, filed by the petitioner against the order dated 25/10/2024, passed by the Land Court of Chief Judicial Magistrate in maintenance case number 01/2022, has been dismissed on technical ground. That where is the, okay, just a minute. The petitioner ought to have filed under section 3 and ought to have filed under section
438 BNSS.
have they mentioned?
Yes, page 54. Page 54.
Ought to have been filed
Second.
under section 438
8
BNS
BNSS instead of
BNSS instead of section
397
397
CRPC.
of CRPC. Fair. issue notice. Whether the record required to be called for here, not necessary.
No, not necessary, I think.
Lordship, scan copy.
Scan copy can,
Scan copy of the TC,
if required, otherwise.
This is
because orders have been not clear.
okay. Call for the scan copy of the file code record. Issue notice. The since Miss L. Hage, Lane Edison PT, appeared and accept notice on behalf of the state respondent number 1. No formal notice need be issued to the state respondent. The petitioner shall take steps upon the respondent number 2 by
2 and 3.
2 and 3.
2 and 3.
Yes.
Who is 2?
Their daughter.
2 is a wife and
3 is
3 is daughter.
okay, daughter. The respondent number 2 and 3 by a registered post with AD as well as by usual process within a week from today's start. This is matter after 4 weeks. Whether they have filed execution petition.
I don't think so, because
You have not yet paid. Not yet paid any amount. Have you? Have you or have you not?
basically this I have to get instruction because I am one of my colleagues appearing that matter, so I'm
As
not
per this
sure.
order, they have the liberty to file education actually application. So till now they have
Only
filed.
liberty
on
has
the-
been given.
Yes,
Yeah, liberty has been
Not-
given,
Not yet filed.
not yet filed.
So no need to stay the execution
But
unless it.
but anytime your lordship, because matter,
When you file, when execution petition filed, you file one IA, will stay because it need to stay. But then since there is no execution petition which is to be stayed,
well, till returnable date, if they have filed, then no issue. Otherwise, till returnable date it can be.
future protection.
Whichever.
The
Till it-
contradiction will be there. Lordship.
Otherwise, we are ready to pay. There is no question that we are not
Then
paying.
what's the problem?
But that amount is only the difference that is being
You
challenged.
can pay. It's your daughter. Pay.
The amount is the only issue. I think that is the issue.
You
So
are
let-
happy, you
let-
are happy with the second wife.
No, like that we decided by the concerned court on marriage.
Pay. It's your daughter only. Not for the mother. It's only for the daughter. I've seen.
Yes, that is there.
No harm will cause, even if you, because there is a arrears also. In any case, you have to pay some amount.
Yes.
But then stay is not required. If they file execution petition, then you file IA, will stay.
My lord,
You
that-
deserve to stay because it's only, it probably on appearance of the party,
Then-
this will have to be sent back to the trial court with the direction, probably, to allow you to amend the
My-
section.
My lord, I think it can be disposed of. I think.
No.
I mean,
Any other affecting the respondent, we will not go for that.
file नहीं किया. I think execution is not filed. I think that.
Not yet filed, that is what I'm saying.
But
Even if filed also, you see.
but I'm not sure, Your Lordship. So
Now, you have to buy, in any case, you have to pay from the date of filing of the maintenance petition. So this is not urgent, 2022. See, some amount, in any case, she is entitled.
I think
amount.
some amount has been paid.
That is why.
Then
Okay,
well,
agent when, immediately, agent when, if you just obtain instruction, if they have filed execution, petition, file one small IA will state.
Then-
They can be
Yeah,
done.
but then you say nothing to be stayed now.
my lord, otherwise, my lord, what will happen is that we don't want to delay the matter. It can be disposed of. Maybe
See, that is why, for disposing of, either I have dismissed because you have not filed as per the proper provision of sections, or it will be the direction to allow you to amend. In that case, because they have a legitimate expectation now, because case has been dismissed, they are expecting that much of amount. But if any order pass against that, it will go against her. Then we cannot, that High Court cannot pass. Adversely affecting the respondent without giving an opportunity. Cannot. On the next date, if you insist, we'll try to dispose of
Then, my lord,
and
your
after,
lordship,
after serving copy, if they don't appear. Okay,
my lord, I
please
think,
matter after 3 weeks.
then, my lord, in
Maybe.
order, it may be reflected, my lord,
What?
that if the education, it may be
What
reflected,
we'll do, the interim prayer shall be considered on the next stage. Okay.
but it may be reflected, my lord, which your lordship has said that one. Otherwise,
Which one?
sometime, I mean, if execution order is filed, then yes, interim will be considered. That can be also reflected. So your lordship may in
Okay.
order. That can be reflected. So that if they file
Okay,
executive,
in the event of filing the execution petition before the trial court, the petitioner is at liberty to file appropriate application. Against the same. Okay.
obliged.
Right.
Lordship, my lord, I want
Yes.
to make some submission on item number 2, my lord.
Hmm?
Item number 2, this order, my lord, I have just now made maybe altered, my lord, because just now my client has called us. He have the copy of the application too, my lord. So instead of withdrawal, my lord, notice will be issued without interim, my lord.
Item 2?
Yes, ma'am. Because on my lack of preparation, my petitioner may not be allowed to suffer.
What do you want there?
Instead of withdrawal, notice may be issued, ma'am.
Notice.
Yes.
You immediately file. Better you file immediately. Instruct that because that one copy of that goes against you probably because in any case, unless those things are there, it goes against you only. It is better you just instruct him to file one application for the order, obtain the copy. There is a copy. Keba decision copy is also there. You immediately file. Ask him to come and sign file challenging the Keba.
Because lordship, this execution in the execution proceeding, my lord, the copy of execution even was not furnished to me.
It's there.
Yes. So we have challenged the execution order only.
In the execution order, see, the case doesn't lie, actually. It should have been dismissed. It's not maintainable at all. How it is maintainable? Too early, unless you challenge the main order. The court always, any court will ask you, have you challenged the main order?
That is why, lordship, I have tried to flash in the same order passed by the same executing court. This court has intervened.
You bring that order there.
Yeah, it is here.
Hmm?
That is why I was trying.
What order?
The intervention of this.
Wait, do you have the copy?
Yes.
What it says?
This is the same passed by the same executing court of the same village for the same issue, man. Of the same place. This is exactly the same.
No. The Keba decision dated so and so, primarily on the ground that you're assailing the Keba decision here. That is different. That is why I'm saying you assail the Keba decision first. Then only that will lie. You have not assailed, not challenged the order of Keba decision. You have not challenged. That is why I'm saying. Even this petition also, you can file challenging the Keba decision. Keba lack of jurisdiction to pass such order. See, this is challenging the Keba decision, not the execution. You first challenge the Keba decision, then file against the execution. In the Keba decision, while filing against the Keba decision, there also you can make interim prayer. No, this is different. The present application filed assailing the Keba decision dated so and so, primarily on the ground that the Keba lacks jurisdiction to pass such an order. Allow me to write this sentence at least. you make averment, I'll pass same order, but then you have not challenged that KEBA decision. I'm asking you to challenge the KEBA decision.
In the CRP.
Hmm? You have not challenged the KEBA decision. Unless you challenge the KEBA decision, how can you challenge the execution decision? Execution court doesn't have any power to change, alter, or to do anything on the order. Only his duty is to execute as per the order passed by the court. He cannot change even the comma I am saying. So executing court, you cannot make any prayer before the executing court except that regarding the execution. Unless you challenge the main order. You challenge the main order, that's better. Oh, yes, yes, item 6.
Your Lordship, this is a regular second appeal which I am preferring before this court, challenging the original judgment and decree passed by the trial court.
This is IA.
One IA for stay first.
IA is for
RS.
state.
Yes. RSA, then IA will come once RSA is approved.
Yes.
This is the RSA challenging the judgment, impugned judgment passed by the appellant court while dismissing my appeal, which I challenged against the judgment.
What was the original order?
Impugned order was that the judge original who had directed me to pay the amount of rupees 65 lakhs, but there was no any documents which says that I am liable to pay to the defendant respondent number 2, who was the original plaintiff.
You were directed to repay. Pay or repay?
Not repay, pay an amount. Actually, one work was executed by plaintiff, who is respondent number 1 herein. It was a government scheme. Originally, the work was awarded.
The respondent is government.
No. It is not a government. This is between the private parties.
Okay. Between the private.
Because
In a title suit.
title suit.
Money suit or title?
Money suit.
Money suit. You were directed to pay 65
lakhs.
65 lakhs
To the respondent number
Plaintiff.
1, plaintiff original.
respondent hearing.
Yes, respondent number
Okay.
hearing.
So have you paid?
No, yeah.
Okay, you filed then appeal.
I file an appeal. In the appeal,
Money appeal.
Money appeal.
Money appeal was dismissed.
Dismissed.
So that was upheld.
That is upheld. So I am
now
here in
challenging the
same judgment and decree
on what ground?
on the ground, because my substantial question is that during the trial, my engaged counsel was engaged by me, had withdrawn his wakalatnama at the final stage.
Is that a substantial question?
That
No.
was one. Second is that there is no any documents wherein it says that I am liable to pay this much amount to the plaintiff.
That is your challenge in effect.
No, this is not. Is there any document who says that I am liable to pay? Because he has to prove it by a documents, by way of evidence. Until and unless he produces the documents by way of evidence, how can only on the basis of assumptions?
Document that was examined.
No, that was not
during
produced.
evidence.
No, that was not produced. That is why I am coming. Because there is no any single document which is produced by the plaintiff wherein it says that I am liable to pay 65 lakhs to the plaintiff. My only work was that the fact is that it was a government scheme. So respondent number 2 and 3 was awarded work was awarded to respondent number 3 originally. So he could not
So
complete.
who are the parties?
The parties
The respondents.
respondent
You said
number,
it's a government scheme.
it was a government scheme. Government had paid to respondent number 3 and 2.
Respondent number 3 and 2.
2
and 3.
2 and 3. So who was the original awardee of the work?
And you are the subcontractor who worked.
No, I am not a subcontractor. I was the JE of that particular department.
You are what?
I was a junior engineer. I was looking after the work of that.
How the money transaction came into?
No, that is the why I am challenging, because it is the contract was awarded to respondent number 3, who in turn who was unable to complete the work on time. So the work was
Who was unable to complete the work on time?
respondent number 2. 2.
And you are for?
I'm the defendant number 2. I'm the J, appellant hearing. It was because work was not completed on time. So I asked them that has to be supplemented to someone else so that that can be completed.
No, now you are for Bajong 13.
Yes, I'm for the Bajang part.
Okay. And then there are respondent 1, 2, and 3.
3.
So whom you were directed to pay?
To respondent number 1.
One only.
1.
What about this 2 and 3?
2 and 3, no. Because when there was an implied contract,
Okay. Now what is the fact? So you are a junior engineer.
yes, I was the junior engineer who was looking after the work, which was a government scheme. So when respondent number 2,
Okay. Then who is this respondent number 1?
respondent number 1, the one who had
Contractor.
executed the work.
Executed the work. Okay. How the money transaction came?
So transaction has to came through because original work was awarded to respondent number 3, who had in turn handed over to respondent number 2.
Okay.
So respondent number failed to complete the work within the time specification. So he had said that I am unable to complete the work. So better it's give to someone else. So he had asked the appellant hearing if he can assign it to someone with the direction and consent of respondent number 2. The work was given to respondent number 1 hearing, the plaintiff, original plaintiff. So he had completed the work. After the work was completed,
Respondent number 1, Jamin Party.
Kevin Party had completed the
Completed the work.
Yes. So when he had completed work, there is an implied contract, implied consent from respondent number 2 and 3, because they had that objective. Once work has completed, when paid, they had received the payment, they should have paid it to respondent number 1, to the plaintiff.
Okay.
So they had that paid. They had not furnished any document showing that on receipt of the payment from the government, they had onwarded, transferred it to respondent number 1 hearing. Or respondent number 1 said that 2 and 3 had paid to me and I had not paid it to. There is no such documents because there is an implied consent between the respondent number
But
2
you
and
were there only at the time of trial. You participated in the trial.
trial. I was there.
Okay. And
So-
examine, cross-examine.
Cross-examine till that time, my counsel was there, then he withdrawn his wakalatnama. So I was not aware what was going on. Even I've contacted, he says that it's still going on.
Okay.
So I will inform.
It proceeded ex parte.
Yes, it's proceeded ex parte against
The decision also ex parte.
ex parte decision.
Okay. Will issue notice. Okay. Mr. Deore, Mr. D.K. Deore, I'm counsel for the appellant. Para. This is a regular second appeal under section 100 of the Code of Civil Procedure 1908, challenging the judgment dated 2/5/2025, passed by the Court of District Judge Teju in money appeal number 01 within bracket LDV bracket close stroke 2023 arising out of the judgment and decree dated 17/11/2023 passed by the Learned Court of Civil Judge within bracket Senior Division Rowing decreeing decreeing the money suit number 04/2022. Start. Being aggrieved, the appellant filed money appeal number 01 within bracket LDD bracket close 2023, which was dismissed. by affirming the decree dated 17/11/2023. Huh? On perusal of the appeal memo, this court is satisfied that the matter involves certain arguable questions of law. So hence issue notice upon the respondent. The petitioner shall take steps upon the respondent by a registered post with AD as well as by usual process within the week from today. In the meantime, it is directed that till the returnable date, whether they have filed any
Execution petitions, I have no knowledge. They might have filed, but I have not received the notice yet.
the operation of the impugn, same, judgment dated so and so passed by the district judge arising out of the order dated so and so, same thing repeat, by the chief judicial magistrate, so not chief judicial, civil judge senior division, arising out of such, subject to the condition that the appellant shall dispose, the appellant shall deposit deposit 50% of the decreed amount before the executing court.
Now it will be executing court.
Before the executing court. Within 6 months, 6 weeks,
6 weeks, okay.
within 6 weeks from
Today.
today,
Yeah,
from the date of receipt of the certified copy of this order.
orders. And
stuff.
as subject to the outcome, that amount should be released. That should not be kept, released to any.
The amount, total amount is 65. It will be naturally 30 plus.
Now 30 plus, that should be kept with the executive court.
No, it will be executing before the executing court only. And for withdrawal, they have to make an application, separate application.
Okay.
Unless separate application is made, they will not be able to disperse it. Okay, stop now. It is made clear that the interim protection shall be operated only upon the compliance with the above condition. Stop. Failure to comply with the above condition within stipulated time shall result in automatic vacation of the interim order. Okay?
So your lordship, so can it be for 3 months? 6 weeks will be too short because it's a huge amount.
Then the interim will operate only after your deposition only.
Yes.
We'll say 2 months.
No, then it's 6 months. That's okay, fine.
2 months, okay.
No. I will deposit within 6 weeks. Then it will come because it's a huge amount. I cannot deposit within this short period.
No. How much time you want?
6 weeks. Okay, fine.
6 weeks, fine.
Fine.
But within 6 weeks from the date of receipt of the certificate of this order. Okay. Okay.
God bless.
Yes.
IA same, it is already given us.
It's IA.
That's
IA
condition is already. This is for the stay of the execution. If
So
any.
then, in view of the order passed, IA stand disposed.
Disposed.
In view of the order passed in the RSA, in view of the order passed today in RSA, 07/2025, this IA stands disposal. Okay.
Publish.
Yes. Item 12. Okay. Yes, 12, I thought it is adjourned, not, okay, yes.
Lordship, I
You
can-
made a prayer for adjournment.
Yes, yes.
Okay, let us just see, huh? You have to take steps upon the respondent number 2. You have not yet taken. Take steps.
Lordship,
Okay. You are Mr.
Mr. Ayun.
Hmm?
Ayun.
Give your name, huh? Okay, Mr. So-and-so, Land Council, for the petitioner, prays for further 1 week time to take steps upon the respondent number 2. The prayer is allowed. Mr. Okay, hello, Land Council, Land people is also present, huh? Yes, list this matter after 3 weeks.
Lordship, can you be listed on 8th of August?
Hmm?
Can it be listed on 8th of August?
28.
8.
8.
Of
It cannot be because you have to take steps. First, huh? Take steps. Within 1 week, you have to take steps, and thereafter, this is matter after 3 weeks. Okay. Okay.
Yes.
My lord, this second appeal, my lord, it is directed against the judgment of the civil judge, but there is some delay. So
Oh,
there
say
two
delay.
delays.
Continuation petition.
Yes,
What
one
are
is for item 192 and 93, 193. There are two IAs. ma'am.
Okay.
One is for delay, condonation of delay in preferring this appeal. And another is for,
Okay, have Mr. This, okay, land council for the applicant. Para, this is an application filed under section 5 of the Limitation Act 1963, seeking condonation of delay, a delay of 183 days in filing the connected second appeal, against the order dated 29/10/2024 passed by the Learned Court of Civil Judge Senior Division Pasigat in civil within bracket Kebam bracket close appeal 71/2023. So issue notice. Returnable by issue notice. The petitioner shall take steps upon the respondent by a registered post with AD as well as by usual process within a week from today. Stop list this matter after 4 weeks. Okay.
okay.
Yes.
Lordship, matter has been referred to special mediation.
Hmm?
board. Matter is referred to a special mediation drive, right?
Oh, yes.
Yes.
This
So-
is regarding
Yes, Your Lordship,
So-
since it is on merit, my lord, so let this
this is
matter
on
be.
merit.
This is on merit, so Your Lordship, it will be better that they take a chance before the mediation, Your Lordship. Because the
Okay.
matter is not been settled, it's based,
The respondent has, where the respondent had appeared earlier.
Yes, they have appeared.
and their
the
name is
private
also
respondent?
Yes.
reflecting, name is also reflecting in the my lord's court list, Your Lordship.
Dabi.
Yes. They've also filed their affidavit, citing that they don't have any objection.
No objection.
Yes, they have filed their affidavit.
Then in that case,
My lord,
what is the offense involved? They have no objection.
Yes, they have filed their affidavit in opposition.
If they were present, it would have been better, of course. What is the,
448, 326, 34.
this was filed way back in the, no, 23 only. Okay, just what was it, 448?
Yes, my lord. Some of the witnesses, some of the respondent, your lordship, service was not completed, your lordship. But what my humble, your lordship, prayer would be, your lordship, since even for your lordship quashing, even if they are not objecting, there must be some consideration, some
Right,
settlement must be
right.
there, my lord.
Settlement is not there.
No,
No, lordship,
settlement-
even
They
this,
have no objection. There should have been some settlement.
exactly, but lordship, this matter has been already settled in the village customary
Then
court, lordship.
why don't you reduce it into writing?
Yes, just after
Just
the
get
occurrence
a
of.
signature, get a signature filed and then get the order. Isn't it?
Yes, sir.
But
until
however,
there is-
lordship, there are some victims. The notice upon victim could not be served, lordship, till then, even after serving several notices, lordship. So far, 11 times notice has been served to the victim, but they could not find it, lordship.
My lord,
Now then, if they are not appearing, victim is a party here.
Yes, I have met victim as well.
Then in that case, sending it before the
mediation, yes, your lordship.
mediation also.
Yes, let them take
That
one
can-
chance before the mediation, your lordship.
That can be, lordship.
If it
Okay,
is
you
done
want to
before
take
the
chance?
mediation,
Okay. But Mr. Haringo, Land Council for the petition. Also, I've also had Mr. T. Land Edison PP.
my lord, may kindly allow me to go to court number 1, my lord.
Please,
Because
On perusal of the record, this court find that there is an element of settlement of the case through mediation stuff. Accordingly, this matter is directed to be placed before the mediator. Stuff. The registry shall take steps for referring the matter before the mediators for settlement through mediation under the special mediation drive. This mediation for the nation. That would be within inverted comma. Okay. Okay.
Lordship, interim is there, interim may be continued till.
Where the interim order passed earlier shall continue till the next date of till then. Okay. Yes. Here also,
Yes, lordship, same.
similar order.
Yeah, similar order can.
Okay, similar order.
And here is also the interim is
Here,
there.
you are for,
Your Honor, I'm appearing for respondent 4 and 5.
4 and 5. Jongludi, you is 4 and, you are Mr.
G.R. Romching, appearing on behalf of J. Jungluju.
Jong. Okay. Then, instead of the additional PP, then record Mr.
G.R. Romching,
Okay. Appearing on behalf of Ms. J. Jonglugu, Land Council for the respondent number 4. Okay. Then similar of the rest. Okay. Yes.
Lordship, interim is also in.
Okay. Similar order interim. Till there.
Much of it.
May I please, your lordship?
Yes.
Lordship, I am appearing for item number 17, 18, and 19 for the appellant on behalf of Mr. K. Sinha. Lordship, here in this three matter, the settlement talks has been already has been made by both the parties, and the appellant has already paid around 50% of the claim amount.
Okay.
And
Okay.
the
Since we
rest.
have paid the half of the sum of the amount, so we are sending it to the.
Yes, yes,
Okay.
Lordship.
You are Mr.
I'm W. Akhtar on behalf of K. Sinha.
Okay. W.
Akhtar on behalf of K. Sinha.
Akhtar appearing on behalf
Yes,
of
Lordship.
Mr. K. Singh, Land Council for the appellant. Okay. And I've also heard Mr.
May I, Your Lordship?
Jessirin.
Yes, Your Lordship. Your Lordship, I have to make a submission, Your Lordship. Since on the last occasion, they've already mentioned that there's a scope of settlement that outside the court, Your Lordship. However, we have to seek an instruction from our party that whether
It's
the
only mediation only. You just inform
Yes,
Yes,
mediation,
sir.
just
My-
appear, and then if they don't like, because what he's submitting,
yes,
it is some of the amount has already been paid.
Already
Yes, Your Lordship. For that,
paid,
to
yes,
that-
Lordship.
to assure that the 50% is whether the paid or not, that has to be ascertained, Your Lordship.
Okay.
So that regard,
Yeah,
that
you-
once,
when the party comes before the mediator,
yes, Your Lordship.
then you decide regarding that. If
Yes, Your
dispute cannot be resolved, then come back. Okay.
Yes, Your Lordship.
And Jessirin, Land Council for the respondent number.
I'm for respondent number 1
Okay.
in item number 18 and 19. I'm
Okay.
not in the item number 17.
One, huh? And 18 and 19. I think they separate order need to be passed now. Okay. I think order will be same only. The right answer for this respondent will be one, huh? And then same order. Okay. Is there any no leave the interim
No.
part? Okay. Okay.
Hello.
Obliged, Lordship.
So this is also for mediation. What is matter about? Criminal petition.
Yes, criminal petition
Is it consensus or is it joint petition or it's on
joint petition.
joint petition?
Yes, already settled.
Okay, there is agreement also.
Yes, Your Honor.
Then
Agreement is
this need not be sent to the, where is the agreement?
agreement. Your Honor, 47, page number 47, Your Honor. Page number 47. 47 of the petition. Is the agreement. And the injuries
Okay,
are
what is the, where is the FIR? Let us see.
FIR is injuries also, Your Honor, simple, Your Honor. Injury is also simple, Your Honor.
Simple, just
Yes.
a minute. This is, dispute is the,
FIR is section, page number 16, Your Honor.
16.
Yes.
Okay, the offense, sections are
Open section 341 wrongful restraint and 341 IPC. Your Honor.
341,
Yes, and 324 IPC. Your Honor.
341,
41 for heart, Your Honor.
324, 341 and
341 and 324, Your Honor.
24.
Yes, Your
Okay.
Honor.
Who is for the government?
Actually,
Call anyone. Who?
PP was the Your Honor.
Ete.
Yes, Your Honor.
Just let anyone appear, will dispose of. Call anyone, any of the government applicant. In absence, it will be difficult, but then any of the government.
Actually, Ete is busy in the port number 1, I think.
Just let us just see, huh?
Yes, Your Honor.
If not, come now. The case is pending before which court?
JMFC UP, Your Honor. It is case of 2011.
Charge sheeted,
Charge sheeted, Your Honor.
trial begun.
Yes, trial not done, Your Honor. It is in the PW station.
Witnesses, some of the
Witness
witnesses already
three.
examined.
3 witnesses were examined, Your Honor.
3 witnesses already examined.
They already examined. The exam with deposition of the witness is
Do you have
in-
annexed the deposition also?
Yes, yes, is in the
Page-
50, page number 52, 52, Your Honor. 52, 52, Your Honor. First was
Just a minute,
informed.
just a minute, let me just see the
Yes.
FIR. They came to my house. Okay, this is a FIR.
Yes, page number 67.
Where do we find the deposition? Charge sheet?
Charge sheet is start from page number 17.
There is an agreement.
Yes, Your Honor.
The offense is only not major. Where is the deposition you say? Evidence of the
Deposition of the complainant is page number 50, Your Honor.
50?
Yes. 50 is complainant, 1 is victim, and the 52 is ocular witness. Ocular witness. 3 has done, Your Honor. Here is this.
Also for mediation, ma'am.
Huh?
This is also for mediation, but it's with case to be.
Yes, Your Lordship, here, Your Lordship, in court number 1, I get little bit confused, my lord. Your Lordship, if the parties have settled the matter, just, Your Lordship, the situation, the parties have settled the matter,
They have.
and if law permits, then Lordship, perhaps in such case, Your Lordship, the matter is not required to be referred to the mediation center.
No, not required.
Yes.
That is what I'm saying.
But Your Lordship, what has happened there, my lord? The learned coordinate bench, I have made a prayer that if they have settled the matter and we don't have any objection and law permits for
It is a
quashing.
joint petition. If it is a joint petition,
Yes.
why to, because they have
Exactly,
already
Your
agreed.
Lordship. If the offenses are not serious, but the other side are contesting, then in such case, Your Lordship, the
Then
matter
it
can
can
be,
be referred.
yes, Your Lordship. If they both are ready and they both have settled the matter, but if law doesn't permit, then definitely state will object.
Yes.
But how the state can enter into a mediation with the...
No, state cannot. State
Exactly,
cannot.
Your Lordship. But one matter has been referred. I made that submission, but the matter has been referred and mediator has been appointed and I was directed to, you just settle with the other side. How that is possible, my lord?
State may not be.
Yes, Your Lordship. Lakshmi Narayan case is there.
Because
State is by default.
State
party.
is not the agreed
Yes,
party.
exactly, my lord. We are just prosecuting the accused, Your Lordship. So here in this case, Your Lordship, they have settled the matter and now law permits for quashing, my lord.
Yes.
So whether under that parameter, whether this case come false or not,
Yes,
that is the only issue to be
yes,
decided.
he said that some deposition also recorded. Let us see if there is any incriminating material.
Yes.
Which can, which will show that just due to misunderstanding only.
Yes.
I think. Then party have settled, I think, thereafter.
Yes, Your Lordship.
So this was recorded way back in 2023. And there also the person who's, he is the PW1 says that I am informed that I am the brother, so due to some misunderstanding, I filed the FIR.
Yes, sir. So that will suffice, Your Lordship.
Gone.
That itself will suffice.
Then thereafter subsequently they have settled this in the 2000.
Yes, Your Lordship.
So can be disposed of?
Yes, Your Lordship. In light of the Lakshmi Narayan case and Gyan Singh, Your Lordship, this matter can be disposed of. Because the offense
the section is, only non-compoundable section is 324.
24.
Yes,
Injury is also simple, Your Honor.
and that's so hard by your lordship, the dangerous weapon. It's a hard.
Yeah, it's allegation only, there was a using of doubt, that was allegation, that was section 324, Your Honor. But the injury was simple, Your Honor,
Mhm.
in this case.
Injury simple.
Yes, Your Honor.
Okay. Hard, Mr.
D. Tamut.
D. Tamut, Learned Counsel for the petitioner. I've also heard Mr. Yete, Learned Additional PP for the state. Okay. So dictation will be taken inside. Okay. This is just the party. How many? Okay. Petitioner 1 is accused.
Accused.
2 is okay. 2 is informant.
2 is informant and 3 is victim, Your Honor.
Okay.
Yes, sir.
Okay. I'll dispose of. Okay.
Obliged.
Oblige, Your Honor.
Oh, khatam hai. Could have taken some there. Okay. The other one, in the earlier case also,
Item 14.
probably. So if they have, had they come into some settlement
Your
or
lordship,
by reducing into writing,
item,
it's also not required to send actually.
yes, your lordship. Your lordship, that is my understanding, because mediation is for the settling the conflict between the two
Or if
parties.
there is a conflict.
Yes,
Because
and-
mediation, what the mediator used to do is call both party once, then if it's settled, okay, if not settled, then one party will be sent out, one party discussion,
Yes, your lordship.
then this will be sent out, another will be called, settled, and then his proposal, this proposal, then he will come into some conclusion and call them again,
Yes,
and
and
then make a proposal.
Yes, your lordship.
settled, this is what.
and how, your lordship, the state can sit?
The state cannot.
We are not
State-
we are not authorized to
State-
sit
state
for
is not a-
mediation, my lord.
State is not a party.
We have just authorized to argue before the court, my lord,
Yes.
not before the
No,
mediation.
no,
It's
that cannot, that
yes, my
cannot.
lord.
Okay.
Obliged, my lord.